Hey guys, Toby Mathis here. And today we're going to be talking about legally protecting your home from lawsuits. And there's a lot of misinformation out there. I'm just going to start off by saying that the number one asset protection tool that we use here at Anderson is to keep your name off of things. There's something called security through obscurity and making it so people can't see what you own. But that's the smoke screen. What we really want to talk about is what actually works if you are in a knockdown, drag out lawsuit. What are the strategies? What are the things out there that actually work against a rabid creditor who's trying to take everything you own? And by the way, I've seen that. One of my first clients that I ever met had lost everything because they were listening to their attorney and their insurance salesman, of course. Oh, that's what insurance is for. They lost every piece of property they had, including their home. And so I'm bringing in John Anderson, who's an expert here at Anderson, who does trust and specifically focuses on keeping assets outside the reach of creditors and integrating it in with legacy plans. So, John, welcome.
Thanks. I'm glad to be here.
And you're always so enthusiastic. All right, so let's go over what options are for people. And I know you're really good at this, so I just want you to lay it out for people. What are the common things that are already there? What are the common techniques that people use? And then what's the best techniques for folks?
So, the baseline for protecting your personal residence is always going to be the homestead protection that you get at a state level. Every state has a different amount of equity that they will protect. So it ranges from zero protection. So, like states, for example, New Jersey and Pennsylvania don't have any protection, homestead protection, and states like Florida or Texas have unlimited protection. So they'll protect the full value of your home. So that's kind of your baseline of, okay, how much is the state going to protect of my equity from a creditor?
And John, can I stop you right there? So what this means is if somebody sues me, and as long as I don't go into bankruptcy, right? Like here's the assets that they can take. They can garnish my wages. They could try to grab my bank account, but they can't touch the equity in my house. Even if I have a $5 million house, right? If I have an unlimited homestead, like in Florida and Texas, they can't touch it. Otherwise, they would just sell my house and foreclose on it to pay their judgment. Is that correct?
Correct. Yeah. And I've had clients that had a creditor coming after them. They actually moved from California to Texas, basically sunk all their value into a property to protect it from that creditor that was trying to go after them. So these are protections that are provided by the state, and they basically can't get to whatever that value is. But again, it varies from state to state quite a bit.
Okay, then what else is there? Because there's some other state protections that some people talk about, right?
So other protections that people will try and do is what we call tenancy by the entirety. Some states allow for this type of protection. Other states don't. It's about 25 states that allow for it. The idea is you put the property into both names, into the name of both spouses. And if one spouse has a creditor coming after them, they can't take that property because it belongs to both spouses. It's tenancy by the entirety. The problem with this type of protection is if something happens to one spouse, either you get divorced or one spouse passes away, that protection is gone immediately. You could literally have two visits from the sheriff in the same day, one telling you that your spouse passed away, and then later them showing up saying, hey, your creditors are taking your property now.
Oof.
So it works to a certain extent as long as there's only one, the creditor is only going after one spouse, and as long as you both are still alive and still married. But
Uh,
if any of that changes, you're not going to be protected.
so that seems like a pretty cursory thing. Maybe if you have a spouse that's in a high risk profession and they say, "Hey, I just want to make sure the house," it seems like that one is the very basic. Hey, we can just retitle the house in some name. I know some people they'll move their property into just one spouse's name, which is its own can of worms. Obviously, in the case of divorce, or if something happens, somebody passes, like you're just you're creating issues that don't need to exist. But what about folks that are, hey, my insurance agent said just get a good policy and umbrella. Like, is that something that you should have, not enough? Maybe it's a first line.
So insurance is something that you should have, but I wouldn't rely on it necessarily to always protect you. Insurance companies are very good at weaseling out of claims, and you got to look at the actual contract. There's going to be exclusions, so yes, it can protect under certain circumstances, but it's not going to protect under all circumstances.
All right. So what are my other options? So you've hit some of the stuff that's with the state. Now, what about things like, hey, I have a huge mortgage on it, so I don't really care.
Yeah, so that was what we would call equity stripping, where you're taking the equity you have in your home and you are removing it, or encumbering it
Mm-hmm.
with some type of loan or mortgage, HELOC, something like that. Yes, that can protect it, but it only works so far, right? One, you've got a loan that you got to pay back. You got interest that you're paying on that. Two, the creditor can still get a lien on the property in second position.
Mm-hmm.
So yes, the mortgage would be in first position and has to be paid back first, but that lien holder in second position can just sit there and wait. They can continue, because once they have the judgment, they can keep that lien rolling over year after year after year until you decide. Basically, you're locked into that property.
We did.
Once you sell it, you've got to fulfill the mortgage and the lien holder before you're going to get anything out of that property. So any appreciation you're giving up on.
We just saw that with the O.J. Simpson case, right? They're petitioning as we speak right now to settle the Goldman claim that was from 3 decades ago. I mean, it seems like it was forever ago. They got a multi-million-dollar judgment. I think they're settling it now for $58 million with the estate. But this is an example of one. O.J. did have the homestead exclusion down in Florida, so he had a tens of $1 million judgment that they couldn't take for the civil judgment that the Goldmans won, but it doesn't go away. Like, they just wait, and that's kind of the punchline here with people that say, "Oh, I've got this or that." Okay, but somebody might be willing to wait 20 years or 30 years to take your stuff, and you get to live in it. That's great. But what about your family lost it, or if the market goes crazy and you get a bunch of equity that you didn't expect?
Yeah.
They're just going to take.
Or if you need to move, you're stuck.
You're stuck. Yep. So that's equity stripping. And now let's get into the kind of hey, some people are throwing these things in LLCs. They're doing some crazy stuff. What is that about?
So the idea is you can put your personal home into an LLC. That's going to provide protection from a creditor, because the LLC provides that protection. It has its drawbacks, right? So if you put it into an LLC, one, you may be giving up on that homestead protection. The homestead protection doesn't apply if it's a commercial property, right? Mm-hmm. Once you put it in an LLC, it's now a commercial property. It can also create issues with the amount of property taxes that you have to pay. Most states have what we call a homestead exclusion, where a certain amount of the property is excluded from property taxes because it qualifies as your homestead. There are also issues where you could lose out on your capital gains exclusions when you sell the property.
So if it's a single owner LLC, the IRS says you're okay, but that's a single owner in a community property state can be a husband and wife, but otherwise it's not. Otherwise, not only do you have the cost of the LLC, but you may have a partnership return you have to file every year if you're not in a community property state. And by the way, there's very few community property states. Most are separate. So you nix your capital gain exclusion on your personal residence, and you get these compliance obligations. You might be saying, why the heck would I do that? Is that something you'd ever advise, or that you've seen people advise and you go, okay, that was smart, or
there are certain circumstances where it can make sense, but you always got to make sure and keep those trade-offs in mind. It's not just a silver bullet that's going to fix your problem of protecting your personal residence. So there's always that trade-off you got to understand. And there's also issues where, depending on if you have a mortgage on the property, if you transfer it into an LLC, they could trigger a due on sale clause.
So
So
there's
it's
so
not
there's
just,
some issues that you'd want to be very careful with. It's not something that is your primary tool. It's something that's going to work in very limited circumstances because there's complexity. Which brings us to kind of the world of trust. And I don't want to steal what you're going to touch on, but I'm just going to say that when we first started this discussion, the security through obscurity popped up, and you can use a grantor trust, which is similar to a living trust. We call them land trusts, privacy trusts, where you get somebody's name off of it. But then there's its bigger brother, which is really these asset protection trusts, and they've really gained steam over the years. How does that work, and is that something somebody could use?
yeah. So domestic asset protection trusts, typically the idea is with a traditional irrevocable trust, these are irrevocable trusts, you had to give up full control over the assets in order to get any protection. But some states have adopted these domestic asset protection trust laws that allow you to still have some control over the assets in the trust, and also be able to benefit from the assets in the trust. So the way it typically is structured is you divide up the trustee powers between three different trustees. And I've talked about these before. You have the administrative trustee who signs the documents. You have the investment trustee who's in charge of deciding, when do we sell an asset? What assets are we buying under the trust? Things like that. And then you have a third trustee who is independent, as a distribution trustee. If you wanted to take an asset out of the trust and either bring it to yourself or give it to someone else, it requires the authorization or the approval of that distribution trustee. And so if you have a home and you can put it into one of these trusts, you have control or the management over the property while it's still in the trust. But someone else has to authorize the removal of the asset from the trust, not you, which means a creditor can't get to it either, because you don't have that authority to take that property out of the trust and give it to the creditor.
So let's explore this real quick. So, in case people are lost, what we're talking about is a domestic asset protection trust. They're created under statute. Where I'm sitting today, Nevada has probably one of the best statutes out there that was authored by a prominent asset protection attorney by the name of Oceans. It's a irrevocable trust. So once you create it, you cannot undo it. You can't unring that bell. But you put an asset in it. It sounds like, John, you'd have a third party who says whether or not a creditor would get that. I'm assuming you still have a certain amount of control to remove that party and say, like, hey, I'm going to switch you, because you wouldn't want someone to give away your house. But if you put something into this, the equity in your house is now protected. What are the drawbacks? First off, did I get that right? And second off, what are the drawbacks to doing this?
Yeah, so the distribution trustee has to approve the removal of an asset from the trust, but they don't actually have the authority to do it themselves.
Mm-hmm.
So they couldn't just take your home and sell it or try and give it to someone else. Plus, you also have veto power over any distribution.
Usually you do that if it's not to yourself. So it's to any third
Right.
party, you can, and you can block it. But would you be able to sit in any of these positions? Like if somebody's out there like, hey, I have $2 million of equity in my house, maybe I'm in California or something. Is this something I can even use? And like, what do I give up by doing this?
So you can use it even in a state that doesn't have domestic asset protection trust laws.
Mm-hmm.
The way you can do that is by tying the trust to another state. So, for example, Nevada, you can set up a trust in Nevada. You just have to have a distribution trustee in that state. And that's what ties you to it. It allows you to take advantage of those laws. So you can live in California, your property can be in California. You create the trust in Nevada, have a Nevada distribution trustee, and that trust can then own that property in Nevada, but be tied to Nevada and subject to those laws.
So I can title the California property in the name of a Nevada Domestic Asset Protection Trust, or we call them Nevada Asset Protection Trust. And now I have a huge amount of equity that a third party cannot just come and take from me, because obviously my distribution trustee would not, number one, would not distribute it to them. Number two, you could block it, you could veto it. But do I lose my homestead exclusion? Do I lose my 121 exclusion, my capital gain exclusion? Do I have a tax implication? Am I triggering anything by doing this?
No. So the trust is set up as a grantor trust for tax purposes, which basically means it's a pass through to you as the person who created it, the grantor. So it still qualifies for 121 exclusions. Pretty much all states allow for a trust to still qualify for homestead protection. It doesn't trigger reassessments. In most states, there's a couple of exceptions where even the transfer into the trust does not trigger any kind of transfer taxes on the property.
Mm-hmm.
So for tax purposes, it's treated as if you are still the owner.
It's no different than a living trust then. So a living
Yeah.
trust is a revocable trust that you can change at will. In an asset protection trust, a NAPT or Nevada Asset Protection Trust, is irrevocable, but from a tax standpoint, they're identical. They're both grantor trusts. They're both ignored until such time as until you pass away, and then there's probably a distribution provision or something along those lines.
Correct. You have some type of a contingent distribution. A lot of times you can tie that even in with a living trust. So if you wanted to change how the distributions are made of your property after you're gone, you can do that through your living trust.
Yeah, so you could say my asset protection trust just distributes upon the passing of the grantors to my living trust, and then you can control everything via your living trust. So why aren't more people using this? I mean, this sounds like, well, what do we call them? Equity protection trust, right? It's protecting the equity in your house so somebody cannot take it from you. It doesn't mean that you get away from, if there's a lien against your house for the mortgage on it, you're not getting away from that. We're protecting the equity, but like, what's the drawback here? Why aren't people using these more?
The main target for domestic asset protection trusts has been high net worth individuals for the most part. There really hasn't been this, I guess, push or targeting of regular people that may have a lot of equity in their home. So it's not really a product that people are aware of there that has even been offered before to most people, because these trusts have been geared. Most attorneys, they target these towards the high end. They don't really offer this to regular people.
Well, let's talk about that. There's two things I want to bring up. Number one is, who is this appropriate for? And number two is, are there any timelines in which you have to wait before it kicks in?
So the way you would want to figure out if this is something that would work for you is, one, you need to figure out how much homestead protection do you have. So if you live in a state like Texas or Florida, this isn't really something you need because you already have unlimited homestead. If you live in a state that has very low homestead protection, then this may be, and you have quite a bit of equity that you've built up in your home. You've lived there for several years and the value's gone up and your mortgage has gone down. And the difference between that homestead protection and the equity that you do have is, something you want to protect. Then this would be something that you may want to consider doing to protect that equity from a potential creditor.
Okay. For people that are wondering what your homestead is, put in the comments down below what your state is, and I'm sure we can have somebody watch this channel and down in the comments and respond to you, or somebody will do it, or they'll point you to the proper statute. States move these things, by the way. So you may be watching this right when this comes out. It may be a year later, 2 years later. We put things on our channel that have been there for a long time. But you could always just reach out in the comments and say, "What is my homestead today?" And we'll respond back. Um, what's the holding period like? Does this thing effective as soon as I transfer a property into it, or do I have to wait a period of time before it's effective?
So there is what we call a seasoning period. It's usually 2 years or 6 months. But if we're looking at a state like Nevada in particular, the way the statute is written, that only really applies to current creditors.
Mm-hmm.
If you have unknown creditors, right, no one's sued you yet,
Future.
then yeah, future creditors, then as soon as you put the property into the trust, it's protected.
So for somebody who's out there and you're like, "Oh man, I know I did something,"
Yeah.
you could still do this, and you have a seasoning period. Like, you're not prejudicing it as long as you don't become insolvent by transferring the asset. That's always the big one. People always feel like they have to freeze, and that a missile is going to hit them if they transfer an asset. It's like, no, you could still do planning. You just can't prejudice the creditor that and become insolvent by a transfer. Which, again, there's a question here is whether you're becoming insolvent. But let's just play it safe, right? Let's just take a look and say, all right, maybe I could transfer some of my equity away. But if you don't have that, then go ahead, and it's pretty effective right away. It sounds like you could actually, for some of these folks that are out there that are in these, gosh, maybe they're in the coastal cities, and they've just had massive appreciation in the last 5 years, and they're like, I just worry a little bit, and I don't want to get another loan and pull a bunch of cash out and put that money over in an LLC or something. Maybe I can just protect the equity. I don't want to mess around. I want to do this kind of fast, down and dirty, get it done, but very effective. It sounds like this could be a proper tool.
And the other great part about it compared to an LLC is the annual upkeep. Once you create this trust and you get the property deeded into the trust, there is no annual filing. There's no annual tax returns that you have to file. It's the old, set it and forget it type of idea. You don't have to, as long as you're not selling. If you want to sell the property, you can. That's not an issue. But if you're just going to be living in the property, you don't have to do anything else after that.
And I believe, I'm not absolutely certain, but Garn St. Germain protects from triggering a due on sale clause. And if this is
Correct.
your
Yeah,
primary
it would
right.
not be subject to the due on sale clause.
So we don't have a bunch of, oh my gosh, I have to worry about due on sale for my mortgage. I'm going to lose a certain amount of protection. I'm going to lose a capital gain exclusion. It sounds like none of that's going to be an issue. So it begs the question again, why more people aren't using this. It sounds like there's just probably a cost to it, and it's going to be really like, is there a threshold amount of equity that you would say somebody should consider doing this? So if somebody has 100,000 of equity, maybe it's not for them. Maybe if it's a higher amount, is there a rule of thumb you guys use?
It's whatever you're comfortable with, right? If you lost that equity, what kind of position would you be in?
Mm-hmm.
And if you're not comfortable with that position, then this is something you may want to consider doing.
All right, I'm going to call that
$100,000 for one person may not be a lot. $100,000 for another person, that may be all they have. So
they want to carve it aside.
Yeah.
I'll call it is the juice worth the squeeze test.
Yeah.
Right. So how much protection can I get? How much does it cost? Speaking of which, I'll put your link. So if somebody wants to find out what it would look like for them in their particular circumstance, what something like this would cost, sounds like there's not an upkeep. There's not a bunch of tax returns. There's not an annual filing fee. So it sounds like it's a kind of a one-time, one and done. And now you have the protection type thing. And we'll put a link so that they could talk to you. What else? Is there anything else that somebody should be considering? Is there anything that we missed?
You had mentioned it at the beginning that, you can hide it as well. So that's kind of a multi-layered approach. So you might not just be looking at just doing an asset protection trust for the property. You might have some type of a privacy trust, land trust, that's going to hold the property so that your name isn't on there. And then you can pair that with an asset protection trust so that if someone tries to get through that, they're going to get stopped by that asset protection trust as well.
Yeah, I personally think that the getting your name off of things has been the secret sauce. I've been doing this close to 30 years, and I can tell you, I've had siblings where one brother had everything in his name and the other brother had a structure in place that had privacy. And the privacy brother got out of a lawsuit where they both were joint tortfeasors. They had a property and they both got sued on, and they went after them individually, and they let go of the brother they couldn't see anything on, like lickety split. He was gone within months. And the other brother got drugged through the ringer for 4 years in a seven figure settlement. So it was like, so I've seen like side by side comparison, and I'll just say the privacy is huge, but at the end of the day, you want to have it's kind of like a moat around a fort. You still want to have the fort. The fort needs walls. That's the entity structure. That's what the asset protection trust is. The moat is, let's make it really, really difficult for anybody to get around. Some people would, sometimes I call the moat your insurance, and then you have your walls, and then you make the walls invisible, and it's just about impervious to anybody's attack. But at the end of the day, you want to have those walls, and that's what that asset protection trust is. John, thank you for joining us again. If you can like and subscribe and share this with anybody you think would benefit, that would be great. And if you want to reach out to John and his team, again, I will put a link in the show notes, or you could actually type consult down below, and we'll send you a link so you can talk to John and his team. Thanks.
Thanks for having me.